Ready? 5 seconds. Start. As per the above statutory provision, the period of 12 years is to be computed from the date when the decree or order becomes enforceable. The question is, when did the decree sought to be executed in the present case become enforceable? Was it from 23rd September 1966, when the period of 2 months for measurement and demarcation of the land by the judgment dater fixed under the decree expired, or was it from the date in 1973 when, according to the decree holder, the judgment dater measured and demarcated the land? For consideration of this question, it is necessary to have a close look at the decree. On reading the decree in its entirety, it is clear to us that in paragraph 1 thereof, the court specifically issued a direction to the judgment debtor to measure and demarcate the boundaries of 13 grounds and 419 square feet of land, or before 23rd September 1966. In para 2, the court directed the plaintiff to deposit in the court on or before 23rd September 1966 the balance of the sale price for 13 grounds, 491 square feet of land measured and demarcated. In paragraph 3 of the decree is incorporated the direction that on such measurement and demarcation and on deposit of the amount fixed in the decree, the judgment debtor was to execute the sale deed in respect of the suit cites in favor of the decree holder at her cost as agreed, and in default the court would execute the sale deed on application of the decree holder, and cost of the execution of the such sale deed on application of the decree holder and the cost of the execution of such sale deed was to be recovered from the judgment debtor. The court took care to fix the same date, that is 23rd September 1966, for both the parties to comply with the respective directions issued to them under the decree. The judgment debtor to measure and demarcate the boundaries of the property, and the decree holder to deposit in court the balance of the sale price of the property so measured and demarcated. The execution of the sale deed was to be done after the parties carried out the directions issued to them, and that is what has been stated in paragraph 3 of the decree, with the default clause that in case the defendant failed to execute the sale deed on application of the plaintiff, the executing court was to execute the same and the cost was to be recovered from the defendant. Such a decree cannot be said to be conditional one, in the sense that the plaintiff could not enforce his rights under the decree till defendant carried out the direction under the decree for measurement and demarcation of the land. The position is well settled that ordinarily a decree becomes enforceable immediately after the judgment is pronounced. However, there may be situations when a decree may not be enforceable on the date it is passed. Usually, this situation arises where in the decree itself the right of the decree holder depends on happening of certain event or on fulfillment of certain other conditions. Stop.